So this comes from chapter 18. This is all part of the judiciary.
Did you say you posted this or was one different?
I posted this on Canvas. It's a PDF version of it. It's not the actual PowerPoint slides.
I got it.
But you're welcome to it if you want to pull those down. So we're going to begin talking through the national judiciary, looking at the federal level of courts to begin with, and most of the stuff that we are going to be dealing with today is on the federal level. Is that going to work for everybody? Is that too dark?
That's good.
It'll work? Okay. I don't know why my projector seems to be a little bit dark today. Our judicial system comes out of Article 3. You should already know that based on our study of the Constitution. And so in the Constitution, it talks about the Supreme Court and inferior courts. Article 3 is the smallest of all the first three articles in the Constitution. It talks very little about our court system, but it does tell us that we shall have a Supreme Court and we shall have inferior courts below that. And so the judicial power was meant to be the least powerful of all three branches of government. However, it has grown over the course of time and through different court cases that have been heard. And so because the Constitution is vague on what types of courts should be established underneath the Supreme Court, and it does not say how they're to be established or who is in charge of them other than they are beneath the Supreme Court, we have given that power to Congress to create new courts underneath the Supreme Court. And so as we have need, we create new federal courts, we create appellate courts to help the Supreme Court in all the decisions that they're having to make. The judicial branch is supposed to have independence from the other three. Now, there is still a checks and balances system, but justices serve for life on the Supreme Court and on the national court. So any of the courts that are formed below the Supreme Court, the federal district courts, the appellate courts, many of those are for life type terms. You cannot be fired. You can, however, be impeached. We'll talk about that a little bit later on. But that's the only way that you can remove one of these people out of office, either retirement, death, or impeachment. Congress cannot reduce the salary of any of these members while they are serving their term. Why do you think they included that? What protection is that giving to the judicial branch? Okay, there is some freedom of speech in there. What else?
It removes like bias that can be like control over, like the Congress can be like, if you don't pass this or like do this, then we're going to reduce your salary.
Yes.
So it gives them independence.
Right. Good. So it gives them independence from being influenced by a congressional threat or blackmail or anything like that. You know, saying that if you don't reverse this law or if you don't uphold this law, then we're going to reduce your salary. So you can't do that anytime during their time in office. The idea of the federal judiciary, we talked about federalism last time we were together, is that they are intended to complement the state courts. When we go back to the Articles of Confederation, they did not have a national court. As one of the weaknesses we discovered and we talked about when we looked into the Articles of Confederation, they had no way of settling disputes between different states. Because every state wanted to have the argument in his own state, they could not come to an agreement, and it was back and forth. So that was one of the big weaknesses there, and that's why we saw the need to have a national court system. In the Articles of Confederation, laws were not enforced consistently, and then there was the idea of exclusive jurisdiction where that state wanted to have total control. I'm not going to go into too much about that. There are times where there is concurrent jurisdiction. this is rare, but it can happen, where both the state courts and the federal court claim to have control over a case at the same time and seem to have equal claim to that case. And in those type of cases, most of the time, it becomes an argument back and forth between the two sides if they really have a strong desire to go toward one or the other. And to be quite honest, I'm not sure how they would settle that, if that would have to go to a higher court or if by default it may go to the federal court. But concurrent jurisdiction means that more than one court has claim to that particular case. We talked about original jurisdiction the other day. That means it's the first to hear a case. So almost every court, once we start climbing the ranks, is going to no longer have original jurisdiction, but once in a while that could happen. You can never have original jurisdiction in the appellate courts because by definition they are appealing a previous decision that's already been made. And so by the time we get to the Supreme Court is always an appellate court. So they've always heard the case has already been heard in a previous court somewhere, except for two cases. Anytime there is a case between two states that are having different opinions or that are suing one another, that could be a direct Supreme Court original jurisdiction. Not always, but it could be. And then cases involving foreign representatives. If we have a diplomat from another country that commits a crime against our country, then the Supreme Court could very easily pick that up and say, we want that here. We don't want that to go to a federal court. Supreme Court cases are always optional, meaning that the justices on the court get to choose which cases they get to hear. And we'll talk more Supreme Court closer to the end today. But those are the only two types of cases that the Supreme Court could be original jurisdiction from what we've seen in history. So, a few court officials, of course there are judges. We have over 1,000 federal judges across the country. Each one of these federal judges need to be appointed by the president, and because of the presidential appointment, who has to confirm them? Who had to confirm Kavanaugh? It was the Senate. Okay, so that same rule applies for all other federal judges that are appointed by the president. The Senate has to confirm. Now, it's not as big of a media circus as what we saw in the Kavanaugh case, but they still have a committee that will question and will investigate, is this person fit? Because he is going to serve for life on this federal level. So the president often looks to interest groups, the attorney general, other senators for advice on men and women that are going to fit the qualifications that they believe would pass and would do a good job in these positions as he's looking to appoint people. So, you want to be a judge on a federal court. Here are the qualifications. Take them down. Don't miss any of them. Did you get them? There are none. That's why there's nothing written up there. Constitution's silent on the qualifications for judges. You have no age limitation. You have no education requirement. You have no background requirement. You could nominate me for a Supreme Court justice.
We will.
Or a federal court justice. I would not pass Senate confirmation because they would ask me all kinds of questions. I don't know. But they could nominate you. I mean, there's no age limit on there. But once again, you're not going to get passed through the Senate confirmation. And so traditionally, qualifications would include having experience serving as a judge elsewhere, many times on the national level in a federal or district court. Most of the Supreme Court justices in recent history have been around the age of 50 plus, many of them around 50 to 55. They have extensive experience, and they typically align with the political spectrum of the president who appoints them, whether they're conservative or liberal. Sure.
So as far as like the citizenship
not by the Constitution. Now, once again, I would be shocked if the Senate would ever go for somebody who's not a citizen.
A 13-year-old non-citizen.
13-year-old non-citizen. How about an illegal immigrant who was convicted of a felony at the age of 12? Good luck with that one.
Mr. Joe,
Yeah.
you know there's a case in Texas right now. This 16-year-old girl that she got sexually assaulted and she ended up killing the guy, and she's serving 50-some years with parole after. But right now the mayor is trying to get her out because the situation was. Whatever. But you know how Texas is with it when it comes to their murder laws
Yep.
and stuff like that.
I'm not aware of that case, so I don't know all the
She got
details in
evicted-
there.
She got evicted like 15 or 16. She's like
Okay.
30-something now.
When judges are sitting on the bench, there's typically two different perspectives that most of these judges will take on. The first one is that idea of judicial restraint. The judge who believes in judicial restraint looks at the original intent of the law, when it was written, how it was written, the context in which it was written, and try to uphold the law and interpret the law based off of the original ideas. They are not looking to make major changes to the law by reinterpreting it. And so they're going to follow the rule of precedent, which means that they are going to rule the same way that other courts before them have ruled. It's a very conservative approach to the court. However, on the other end of the spectrum, you have the judicial activist type judge. And this is the person who is going to look at the current values of the law. They don't really care about, I shouldn't say they don't care. They're not interested in looking at the original intent of the law because the original law was outdated. It is no longer fitting for current society. It needs to be interpreted much differently because our society is different today. And so they are going to look at previous precedent and disregard any impact on this case because that old precedent is old. It doesn't fit for today's society. And so we are going to come up with a new interpretation based off today's society. If that somehow aligns with the previous decision, then so be it. But it's my job on the bench to reevaluate based off of today's current situation. Most judges fall somewhere in the middle between these two. But there's a sliding scale, just like we talked about with the political viewpoints. If you are more liberal toward the left or more conservative toward the right, many people fall somewhere in the middle. Rarely does somebody fall directly in the middle. You tend to lean one way or the other. The judges work the same way. There's usually not somebody who is far toward the restraint side and far toward the activist side. They tend to fall in the middle but have that sliding scale. Sometimes it varies based off of the issue that's coming up as well. Most of the judicial activists would be proponents of expanding civil rights and social welfare for the new interpretation of the law. Because many of those programs and many of those ideas were not originally included in our older laws. They would look for ways to insert them or to reinterpret them, promoting ideas of civil rights and social welfare. If you are appointed to a federal court position, so I want to also make sure we're clear here. This is not just the Supreme Court. This is also, really we're not talking about Supreme Court right now. We're talking more about federal judges below the Supreme Court in the district or appellate judge circuit. So most of these judges are going to have a life term unless they serve in a special court. Special courts are courts like special tax courts, courts that deal with veterans and current military members as they go to the Court of Appeals. They have a whole separate court system for them in the military. So unless it's a special court, these federal judges serve a life term. So the only way to remove them is by impeachment. The impeachment process works the exact same way, or very similar, I should say, to the presidential impeachment. House of Representatives gets the research, they get to drop the papers, they get to file for impeachment, and then they send it to the Senate, and the Senate becomes the jury on that. In their compensation package, They get paid full-time, and if they reach the age of 70 years old and they have been serving for a minimum of 10 years, they have a retirement option. They're not forced into retirement, but they have the option and they get to choose. At the age of 70, if they choose to retire, they get full benefits and pay for the remainder of their life, and they get to walk off the bench. If they have reached the age of 65 and have been serving for a minimum of 15 years, they will also get that full pay and benefits for the remainder of their life. So that's a pretty good setup for a 10 to 15 year job that you've committed to. Yeah?
Why is there one for both 65 and 70? Like, why can't they just retire at 65?
Because of the age at which many of these are appointed. More recently, most of our justices have been appointed in their 50s and 60s. So they're trying to make, 65 is often considered to be the retirement age. So they're trying to make a way for them to retire. They'd really like for them to retire around the age of 65 or give them that option to, but if they get appointed at the age of 60 and only serve 5 years, it's not really fair to let them do that. But we also don't want somebody who gets appointed at the age of 60 to have to serve until they're 75 in order to get their benefits, and they really should have retired 5 years ago because they're not going to be effective. So they get the option to retire. There's no forced retirement. They can have a vote of no confidence from the Senate, but that's very rare. It's kind of like the 25th Amendment. So most of them realize when it's time for them to retire, they fade off into the sunset. They step down willingly. But they do have that option. So if you retire, then you are considered to be a judge emeritus, which means that you get this title but no responsibility. Many times they will welcome back the previous judges for advice on certain cases, and they will ask them, what do you think on this? How would you rule? That does not have any bearing on the case, but the judge emeritus can come in and can offer some wisdom and advice there. I think we have one or two right now who are still living that have retired. I can't remember for sure. I think Stephen Breyer is still alive. I think he retired. Anyway, so let's get a couple more of these court officials in here. The only thing that I am looking for you to remember here or to be familiar with the U.S. Attorney is that we talked about the court system, and in the civil cases, we don't have the prosecuting attorney, we have the plaintiff. In the criminal cases, we have the prosecutor. And so on the U.S. level, on the federal level, we have 94 different U.S. attorneys that they all are appointed by the president, and they decide what cases they're going to prosecute. So let me ask you this. Why would it matter who these guys are and which president gets to appoint them? If their role and their job is to select the cases that they're going to prosecute, and they are going to help provide evidence and put people into jail, and they're going to determine, or they're going to request a jail term for those people, why would it matter if a conservative versus a liberal president gave these people their jobs? How's that going to affect citizen life? What do you think?
Well, like right now is like a drug problem in the United States.
Okay.
So if you have a conservative judge, they're probably going to be tougher on drug cases.
Okay. So let's use the term prosecutor here instead of the judge. So this prosecutor is going to be very tough on that because he would align with the more conservative viewpoint that is going to have harsh penalties, harsh sentences, especially for repeat offenders. What about let's look at the gun control issue. On the conservative perspective, what do most conservatives think about gun control laws? Are they for or against them?
People should have guns.
People should have guns. So if there are cases involving legal use of guns, but it was an accident, is the prosecutor likely to put a harsh penalty on that person? Or is that prosecutor going to maybe give him a slap on the wrist or going to give him a little more leeway on that? Probably the second, right? However, if that prosecutor is more liberal and wants to get guns away altogether, and he sees a minor gun offense, he is going to nab that one and he's going to try to make a point of that. And so that's why, even on this level here, it's important to know who the president is appointing. And these guys only get a 4-year term, so it rotates every time a new presidential election comes up. U.S. Marshals, also presidential appointment. They are the sheriff of the federal district courts. Like you'd see on TV, we've got the bailiffs in the local courts. You've got the U.S. Marshals that serve in the federal courts. That's about all that you really need to know about U.S. Marshals for right now. This did come up in one of your assignments with a U.S. magistrate judge. These are federal judges, but they're not presidentially appointed. We found that many of the federal judges were becoming overwhelmed with the duties that they were supposed to accomplish and just didn't have enough time to get it all done. And so we created this new position that, in my mind, I think of it a little bit more like an assistant to the federal judge. Yeah, I know where some of you are going with that. So he gets appointed by the U.S. District Judge to be his assistant. He gets to serve for 8 years. Remember, the U.S. District Judge serves for life. So he, every 8 years, gets to reappoint somebody. It does have to be approved. But this guy takes care of some of the daily tasks. He takes care of setting bail and issuing warrants and those type of things. So many have gone through U.S. magistrate judge positions to earn some respect among the judicial community, and then also get their name out there for a life appointment as a U.S. district judge. So it serves as a stepping stone for many as they're pursuing that career. Now, I'm not going to spend much time on juries because we've really already talked about juries for the most part. Article 3 talks about the fact that you have a right to a jury in a federal crime, a fair trial by your peers. Amendment number 6 tells you that you have a right to a jury in a criminal case. And amendment number 7 says you have a right to a jury in a civil case. Have any of you heard about the apartment complex on the west side and the controversy over their contracts regarding these amendment number 7? So this came up in the news just this week where there's an apartment complex that houses a lot of Purdue students, and they are changing their contract. And in that contract, in the fine print, if you sign that contract, it states that you waive your Amendment 7 right to a civil jury trial if you were to ever take them to court, which means that you can still sue them, but it's going to be a bench trial. So what's the difference between a bench trial and a jury trial? No jury. Yeah. Okay, it should be kind of self-explanatory. It's you, the judge, and the other side. So you waive your right to a jury trial. Why would they do that? Jacob?
Because for them, as the defendant, as a company, the jury's probably going to be more biased towards an individual than the company, just because all juries have bias, and so the prosecutors and the defending lawyers or attorneys, or whatever the term is, they pick out what they think will be best. And the attorney probably said, if we do this, we'll win more.
And it's because they just lost a case that went to a jury trial. And so because they lost that lawsuit, they have now changed their contract. So if any of you are thinking about signing a lease of an apartment over by Purdue, you better read the fine print and decide, are you willing to give up your right to a jury trial if you ever had to file a lawsuit against your apartment complex? So question came up, is that legal? Can you do that? What do you think?
My
Is
dad's-
the company allowed to force you to sign a document that waives your right to a jury trial?
My dad's attorney said signatures are only as good as the material you put them on.
So do you think it would hold up?
I have no idea. That's just what he said.
Okay. I would be really interested to find out because they are a private business, and so they have the right to lease to whomever they want to. And you are willingly going into a contract, and by signing that contract, you are affirming that you have read it, whether you actually do or not. So you're both willingly entering that agreement. And so if you sign it without reading it or without being aware of the consequences of that, I tend to think it would be upheld in court, but others disagree with me. So we'll find out when somebody decides to take them to court on that. The bailiff is the enforcer of the law in the room, should he be needed. Stenographer is a really great job if you can type well. These guys get paid, or ladies and guys get paid really, really well, but you have to be able to type crazy fast without very many errors. So if you want a good job that doesn't require a lot of time and effort, learn to be a stenographer. The other job that's really good, I had a former student of mine who he knew sign language because both his parents were deaf, and so from a young age he learned how to sign. And so all through school he signed as an interpreter for his church. He found out that he could go down to the courthouse and they would hire him by the hour, and I think he said they paid like $25, $30 an hour as a high schooler, and he went down and made really good money after school and on the weekends and stuff when they had court cases on the weekends in the summertime. And then they wanted to hire him full-time, paid him really, really well, and he only had to go in when they had court cases or when they had somebody that was deaf. And so he was on the full-time staff, but they just called him up and said, hey, we need you in today. Okay. Tomorrow they didn't call him, so he didn't have to go to work that day. That landed him a job then on the set of a movie with Dwayne Johnson. And so he got to teach Dwayne Johnson, known as The Rock, how to do sign language for a movie he was doing. And so I see these pictures on Facebook of one of my former students, arm kind of around the waist of this massive dude, and he's talking about how he's teaching him sign language for a movie, and man, that's really awesome.
What's his name?
What's my friend's name?
Yeah.
Paul Kelly. Probation officer, I'm not going to go into any of that stuff for right now. Let's talk inferior courts, though. And I'm going to skim through a few of these things also.
Is that the one? I think that's the picture from yeah, that do look like
In the U.S. districts, we have 94 different district courts. There's typically just one judge there. Most of the courts that have original jurisdiction would be here in the U.S. district courts, so they're going to be the first ones to hear it. Before it gets to the district court, it's going to have to go through the grand jury. And the purpose of the grand jury, I think we talked about this back in Amendment number 5, is that they are going to look at all of the evidence that's been collected, and they're going to determine, is there enough evidence to waste, or to use, I shouldn't say waste, to use the court's time with this case. The grand jury is typically made up of 25 to 50 members who are then going to look at all that information, and they're going to weigh in on it and move forward if they think there's enough evidence, or stop the process if there's not enough. If they decide that there's enough evidence to go to trial, they will issue an indictment. Indictment is that formal charge or formal accusation against a person for committing a crime against the laws that exist. If it goes on to trial, that is where you will have the petite jury. Petite jury is smaller than the grand jury. Should be able to get that through the names. But typically the petite jury is somewhere between 6 and 12 people. There's usually not a set number that the laws state you have to have in this petite jury, but typically it's 6 to 12. And they're going to determine guilt or innocence. So the jury has to decide unanimously on guilt or innocence, and you sit there and talk it out with everybody else until you come up with a unanimous decision. these are all the constitutional courts that are in there. I am not going to spend much time here. The only thing I'm going to mention in this one is that in the appellate courts, if you lost in the district court and you appeal to the Court of Appeals and you lose there again, that is the final decision. There's really not a whole lot of options that you would have at that point. The only thing you could do is go back and claim a mistrial or that there was some sort of injustice that had been done. You cannot appeal to the Supreme Court and say, hey, these two lower courts said no, I want you to listen to my case because I think I'm right. They're not going to. So decisions are usually final in the appeals court unless you can get the Supreme Court. I think we can slide past this one. These are the special courts I mentioned. I'm not going to ask you to list those out, but these are the ones that have the limited terms for the justices that are there. I want to talk more about the Supreme Court today, because this is the one that we often associate with the judicial branch, but there is clearly a lot more beneath the Supreme Court than what we often see in the news. So, Supreme Court is the highest court in the United States. Their job is to interpret the Constitution. Their job is not to write laws. Their job is not to enforce the laws. They are not even to reinvent the laws. They are just to interpret the Constitution and what it says. And so they're also going to hold Congress and the President accountable for any violations against the Constitution. They received the power of judicial review through the court case in 1803 of Marbury versus Madison. Who was our second president of the United States? John Adams. And what did he do in 1801 prior to leaving office? The Midnight Appointments. He passed the Judiciary Act of 1801, which allowed him to be able to add more people into federal positions. Of course, he and the new president, Thomas Jefferson, did not have the same political views, and so he thought, I'm going to mess with Thomas Jefferson's administration by appointing all these guys to the federal positions that will serve for life. Pretty good idea, right? Because now Jefferson is stuck with him. How can you remove those federal judges? Impeachment, or they die or they retire. So Jefferson would be stuck with all these guys that have a different viewpoint in the judicial branch. And so one of those guys was Mr. Marbury. I can't remember his first name, but he was supposed to receive one of those federal judge positions, and James Madison was the Secretary of State, I believe it was, in Thomas Jefferson's administration. So Thomas Jefferson was instructed by John Adams, do not let Mr. Marbury take his seat on the bench. I'm going to fire him. He's not allowed to have it. Before he even gets in there, he can't have it. And so Mr. Marbury took Mr. Madison to court and went to the Supreme Court. And John Marshall was the Chief Justice at that time. And very wisely listened to this case, and instead of ruling in favor of one side or the other, anybody know what he did? He said, I am not going to rule in your case. Instead, I'm going to look at the legislation that was passed in 1801, and I'm going to say that was unconstitutional. That should have never been passed. So therefore, this argument that you're having right now doesn't exist, because the Judiciary Act of 1801 was unconstitutional. I am striking it from the record books, which means that John Adams' midnight appointments were all illegal, and therefore, you guys have no argument right now. So he never actually made a decision, but in his indecision or his shrewdness, he decided that he was going to establish a precedent where the Supreme Court could declare laws unconstitutional. That is not in the Constitution, but that's the work of John Marshall, and everybody has followed that precedent. And this is that rule of precedent, is that courts should follow the decisions of similar cases. Precedent never works from lower cases up to higher cases. So Supreme Court is never going to look at a lower case as a precedent and follow what a lower court decided. But the lower courts will always look to the Supreme Court and make a decision based on that. Supreme Court always sets the precedent because they are the highest court in the land. In the Supreme Court, our Chief Justice is the head of all 9 justices. The Chief Justice is not the longest serving member. Chief Justice is an actual position that is appointed. So when the Chief Justice dies or retires, that seat opens. The president who appoints has the option. He could slide one of the other justices into that seat, or he can bring in a brand new person, as George W. Bush did here with John Roberts back in the mid-2000s. The Chief Justice at that time was William Rehnquist. He died, and so that seat opened, and instead of bumping up somebody else, he said, I'm going to put somebody new in that chief position. So John Roberts. Congress actually is the one who decides a number here. It does not have to be 9. That's how many we currently have. But we have had all kinds of different numbers throughout the course of our history. And that's why FDR thought that he could get away with packing the court in the late 1930s, because the Constitution is silent. So he went to Congress and he said, I want to put 6 more justices on the court. And that way they will all be on my side and they will help uphold the New Deal legislation that the Supreme Court is threatening to kill right now. And Congress said, we see what you're doing. That's not what we're all about. And they denied him that opportunity. And so we remain at 9. Most of the jurisdiction for the Supreme Court deals with state disputes or foreign dignitaries. These would be the only times where it would, I guess I should back up, I said that wrong, that they're mostly appellate except for cases of state disputes of foreign dignitaries. So all these other court cases that the Supreme Court will hear have already been heard in lower courts except for these 2. I'm just going to put all this up here and talk about what's most critical. Supreme Court generally operates between October and June or July. They listen to less than 100 cases each year. Because they're so significant, they want to keep their time and focus on those 100 cases, give or take a few here and there, but that equates to about 2% of all those that are applied or asked of the Supreme Court. So your chance of making it to the Supreme Court is extremely small.
So they're doing like a case every 3 days, basically.
Pretty close. A lot of them are kind of overlapping. Typically Mondays are the argument days. And so I believe, unless there's a special circumstance, Monday is the only day that they actually hear cases. The rest of the week they are spent reviewing, going over documents, debating, talking amongst themselves. And so they do a couple of cases each Monday in order to get somewhere to that 100. In order for your case to be heard in the Supreme Court, they have to issue a writ of certiorari, or certiorari. My Latin is not great, so I abbreviate that to the writ of cert because it's much easier to say. And the important thing about this is that you do not get to the Supreme Court without them issuing this document to you. It is a Latin term for all of the information to be collected. They want all the documentation for the case to be brought into the Supreme Court. They want all of the previous decisions on this case to be brought in. And the 2 most likely scenarios for the Supreme Court to issue this writ of cert is urgent constitutional questions and resolving splits in the lower courts. And so those are the 2 most likely scenarios you'll see there. If you get a writ of cert, you're going to prepare your brief. There's only a few people that get an opportunity to talk in front of the Supreme Court. If the case involves the United States, we have a Solicitor General who represents the United States and defends or presents the case on behalf of the American government. If you are the prosecutor or defense lawyer who is brought into the Supreme Court, that is usually a very high mark on your credibility. And so very few actually get to argue there, and so if you do, that's pretty awesome. Amicus curiae are the friends of the court. If they want a third person or they want additional people to speak in front of the court, then they will issue this along with a writ of cert if they believe that it will help make a better judgment. And so typically there's only two arguments that are made. There's the prosecution and defense, or it'd be the plaintiff and the defense. Sometimes they'll bring in a third or perhaps a fourth with this Latin term here. During the briefs, you get 30 minutes. That's it. So you have spent months or years prepping for this moment, and you get 30 minutes. And you'll be in the middle of your final statement, ready to come to a conclusion. You're at the climax, just about ready to make your most important. They will literally cut the mic off from you at 30 minutes. You don't get to finish your statement. You don't get to finish your argument, even though you've prepped and like this was going to be your concluding moment. Unless one of the justices says, hey, I'll give you 2 more minutes. And if any of you followed last year the Supreme Court's decision on the bakery from Colorado, I think, if I remember correctly, they actually did that where they said, I want to hear 5 more minutes on this case and on this argument. And so they gave them a little extra time to argue that.
How many times can they do that, though?
They're the justices. They can do it however many they want. But they want to keep, in their mind, in the Supreme Court operations, if you cannot make your argument and state your case in 30 minutes, then you're wasting the court's time. They want you to be concise, to the point, very direct, and be well prepared to present your argument in 30 minutes. Now, you're not interrupted during that time. It's just you got 30 minutes to the floor. You make the most of it. So you better do it well.
Do like people speak just really, really fast during that time?
You know, I have never been in there. I could not tell you because there's no recording devices that are allowed, and so there is a gallery that you can go in, you can listen in if you can get in, but it's not easy to get in. So I don't know if it's you just have to work super fast or it's you are very careful about the way that you present it and the words that you use. So they spend months and months going over the way they're going to present their arguments because they know it's such a significant moment. So when the courts make their decision, the majority opinion will become the binding decision. So we have 9 members in the court, 4 are on this side against whatever argument's being made, and 5 are in favor. So 5 win every single time when there's a majority there. That now becomes a new precedent. And then we have the 4 over here on the losing side. The 4 justices get to write a dissenting opinion, and they get to talk about why they disagree with the decision that was made. And that gets published, and the public can hear and see what's going on. The winning side gets to write a concurring opinion, or they get to write a majority opinion. And then if you want to write something in addition to what the leader of that group decides to write, you can write this concurring opinion. So you can say, yes, I voted with the winning side, but for a different reason than what my colleagues did. And so that allows you to be able to share your opinions and viewpoints on that.
Who won the bakery thing again?
The bakery one, yeah. So they're being sued because they would not perform wedding cakes for same-sex weddings, and so they were being sued for discrimination. And the Supreme Court said they're a private business, so they have the right to refuse service to anyone.
I thought so.
How did they get all the way to the Supreme Court?
Years of arguing in lower courts, and there are a lot of details that have come out since that have made it seem more and more like a targeted issue, where the 2 guys that went in to ask for the cake did not live anywhere near the bakery, and they were being sponsored by a group that was promoting the I can't remember how many initials are in the movement of the LGBT.
I just
Yeah.
feel like that's a common thing, like it's a private business.
Yeah. But they were basing it off of their sexual preferences as to why they're being discriminated against, and they claimed that was a First Amendment violation. And so because it was a constitutional issue, they believed they could take it to court, get a Supreme Court, and it accomplished their goal. It got it in national headlines. It got it to the Supreme Court. They just didn't win. And I'm glad it went the way it did because of the ramifications of other things as well, because like you said, it's a private business. They should be able to do whatever they want. Now, I don't agree with racism or sexism or anything that is going to discriminate, but based off of religious viewpoints, I think people need to have their freedom to be able to refuse service to anybody they want to as well. Plus, there are other bakeries, there are other places they could get that service.
Sure.
It's not as if it's the electric company refusing them electricity.
They could go to Walmart.
Yeah.
So why didn't they just say, like, it's freedom of speech and just leave it at that, instead of going all the way to the Supreme Court?
Because the two guys kept filing the lawsuit, and they kept winning. They won in one of the lower courts, and then the bakery won another one, and different courts are finding different decisions based off of the viewpoint of the judge who was making that decision. And so because there was that disagreement, see, the bakery was being sued for cash value, and they couldn't afford it. They were going to have to close their business, and they were going to lose everything if they lost. The guys just wanted their civil rights to be defended, and they believed it was a violation of civil rights. Yeah.
But like, if you're looking at it from that point of view, and like, like in the '60s, it was a big problem with racism just because how commonplace it was. But like, you look at America today, like it's still somewhat of a problem. But from like the popular view, if someone's openly racist, then people are going to shun them.
Right.
So do you think that's part of the reason why it wasn't as a big of a deal during that time, looking at this from discriminating against them for their sexuality, where it's the laws in place are the laws in place are good enough, right?
I think it's a matter of making sure that the laws we have in place are being enforced fairly and equally, and that people are respecting those laws. And I think that in some cases, there are people who are trying to expose those that they don't believe are actually following those laws, and so they're trying to make a big deal out of it. I do believe that there are people around the country that are not following those laws, that are violating that as well, and so it becomes a tricky line there too. But when we look at the Supreme Court members, only one that I'm really concerned that you know for right now is the Supreme Court Chief Justice, John Roberts. You need to know his name. As you go through these slides, and I'm just going to flip through them really quickly, they're on canvas for you if you want to know more about each one of them. You'll notice a theme that most of these guys and ladies were appointed in their 50s, and they all align with the president that appointed them, whether they are conservative or liberal. And so Chief Justice I put first on these slides. The rest of them are in order in which they were appointed. And so seniority kind of goes along with the order of these slides. So Clarence Thomas, Ginsburg was appointed by Clinton back in '93. A lot of people are anticipating that she will be looking to retire in the next few years. It's just a matter of whether she decides that she's going to wait to retire until after the next election, or whether she's going to retire sooner. However, she is still very sharp and doing a lot of really important work on the court, and so it's hard to say what's going to happen with her. Stephen Breyer is still on the court. Samuel Alito, Sotomayor, Elena Kagan, both Obama appointees. Neil Gorsuch was Obama's first, and then we have Brett Kavanaugh, who is the most recent. Now, one of the interesting stories I heard about the about the justices on the court is that they have a certain number of traditions that do happen among new members. The newest member has to sit closest to the door in their conference room, because the newest member is responsible for going out and collecting food or coffee or whatever it is for the rest of the justices. That is true. Elena Kagan sat down with, I think it was National Geographic, to do an interview on her first year in the court, and she talked about how she thought they were joking, and they said, no, we've all gone through it, we've all had a chance to do it. And so I think she said it was Clarence Thomas, but I don't remember for sure. He seems to be kind of a prankster, and so he would often send her down for stuff that didn't exist and say, hey, I want you to go down to the cafeteria. I want you to get me some mint chocolate chip ice cream. And she'd go down there and there'd be none. And she'd be sweating because she thought, I'm not going to have it for him. He's going to be upset. And then they'd all be laughing when she got back. And so there's also the highest court in the land is in the Supreme Court. There's a basketball court up on the rooftop. There's a gym facility up there for them to get exercise. And several of the justices have actually injured themselves by getting too competitive. I think it was actually Ginsburg that is one of the most competitive, and she gets pretty feisty when they get up there and play basketball. So, yeah.
Why did it go to the Supreme Court? I bet that's her favorite call. Charge.
There you go. A couple of things on the court. We already talked about Marbury versus Madison as a Supreme Court important court case. McCullough versus Maryland talks about the supremacy clause that stated that now is enforced as the Constitution is the supreme law of the land. And so no other law can supersede the Constitution, which we all take for granted today, but that had to go through McCullough versus Maryland. And then the Warren Court was a very instrumental court in the 1950s and 60s. So they decided Brown versus Board of Education, which reversed the previous ruling of segregated but equal, or separate but equal, that had been in place for well over 50 years. And so Brown versus Board of Education said that segregation in schools is now illegal and that you could no longer do that. That case came out of Topeka, Kansas. Miranda versus Arizona was also decided in the 1960s, which a individual was arrested in the state of Arizona and was not informed of his Fifth Amendment rights and took it all the way to the Supreme Court and ended up getting released because he did not know that he had the right to remain silent. And so it also reminded us that there is no evidence issued without a warrant, and that causes a couple of problems we're going to mention here, I think on my last slide. Roe versus Wade is what we typically think of as the abortion case. However, it really did not. That's more of a nickname for it. It dealt more with a woman's right to privacy and the fact that it's her body and she gets to decide what happens to things going on inside of her body. That's the way the court ruled in that case. So when or if this were ever to be reversed, it would either have to come by a new law that specifically forbids any sort of abortion that would not necessarily overturn this case, but it would say that a woman has her right to privacy, but it would have to acknowledge the fact that the unborn child is a human being and has his own rights or her own rights as well. Or the other way that that could be reversed is another Supreme Court decision. And the Supreme Court could say, we're going to reverse this previous decision, but that would also have implications on individual right to privacy. Yeah.
Didn't they just vote about this like a couple weeks ago, something about abortion? Because I heard Kavanaugh voted against it.
You know, I did not hear about that, so I'm not familiar. You are probably right, but I did not catch what's going on there. The last couple here, I'm going to jump past, go down here to stare decisis. This is another Latin term that means let the decision stand. Those who are judicial restraint inclined justices would be more likely to use this term, where they want to let the previous precedent, the previous decision stand as it is. They don't want to make wholesale changes to things. And so, in reality, the Supreme Court tries to do this as much as possible unless they see a violation of the Constitution. They believe that there needs to be some major change. They want to let the decision stand. This can also be applied to many other courts, not just the Supreme Court, but they refuse to change the precedent when using stare decisis. Last slide today. So there is another concept called prior restraint that is very controversial. The president believes that he has this right, and the courts tend to flip-flop back and forth as to whether or not this is a violation of the First Amendment. So when there's information that would be harmful to the American public or harmful to a politician's career. He may claim prior restraint. And it's the idea that this news story has reached the hands of a reporter. And I know there's freedom of press in the First Amendment, but I want to put a government action on that reporter to prevent him from publishing that story. So I am going to restrain him prior to him publishing that story. And I'm not physically going to arrest him, but I'm going to lock down that story to make sure it does not get out in the public. Of course, it is a violation of the First Amendment, but in the interest of national security or the interest of my own protection, is that something that should be legal? Is something that has been argued and discussed quite often.
That's why you get a flirty press secretary.
That's why you get a what?
A flirty press secretary.
Yeah. Not sure if we want to go there.
No, do you get the reference?
No.
From Designated Survivor.
Oh.
Remember with the child? So he like had his press secretary who had been flirting with the one reporter.
I vaguely remember that part. It's been a while since I've watched that, but I vaguely remember a little bit now.
Yeah.
Okay. The exclusionary rule, that's okay. I appreciate the reference. I just didn't catch it. That's my fault. The exclusionary rule is any evidence that is obtained illegally. Exclusionary rule means that you cannot use it. This has happened in a number of cases where people went in without a warrant. They found the murder weapon or they found drugs or something, had DNA on it or had fingerprints on it. It was directly linking the person to the crime, but it was obtained illegally. And if that can be proven in court that it was obtained illegally, then they can tell the jury that they must exclude that from their decision. So if the jury does not have evidence to support their decision and that evidence has to be removed, then they will probably have to vote not guilty. So exclusionary rule removes that, cannot be used in any sort of argument.